Today, I'm joined by special guest Chasity Sharp Grice, an esteemed elder law attorney at the Estate and Family Law Group in Tennessee. With deep roots in Tennessee, Chasity launched her own law practice back in 2010, specializing in the areas of probate, estate administration and litigation, estate planning, and elder law. In our conversation, Chasity explains how to navigate ethical complexities that often arise when working with senior clients facing diminished capacity. We'll also dig into some of the ethical responsibilities elder law attorneys have to their clients, especially in tricky situations like undue influence or family conflicts. Hi, Chastity. Thank you so much for joining us today.
Thank you for having me.
Absolutely. We're so excited to have you today because we're talking about a topic that comes up a lot in the elder law arena. So, we're talking about working with elderly clients who might have diminished capacity and kind of some ethical concerns and what you should be aware of when working with these clients. So, the first question I want to ask you is right away, starting out with that initial consult with the client and maybe additional family members. What are you looking for, or maybe asking the client to determine if they have any diminished capacity?
That's a great question. So, one of the things that I want to look for is, well, I want to acknowledge what the physical and or mental impairments may be. It may seem simple if one would ask the family member, well, do you know of anything that would lead me to have some concerns today about this person's impairment? Unfortunately, there may be a situation where the family won't be honest with you. And more specifically, your client isn't always going to be responsible, or they're not going to be as responsive to you as you'd like them to be. Now, Comment 6 to Rule 1.14 of the Model Rules of Professional Conduct, it says specifically that when you're determining the extent of a client's capacity, specifically if you think that the client has diminished capacity, you have to consider certain factors. You have to consider the client's ability to articulate their reasoning behind a decision that they're telling you that they'd like to make. You have to understand what their state of mind is at that time and whether or not they have the ability to appreciate the consequences of what they're asking you to do. Now, in real life, that sometimes is more difficult than it sounds, right? So sometimes it's a matter of understanding your client. If you've had a long-term relationship with that client, it is obviously a lot easier for you to determine if they have diminished capacity because the client, you know what the client has told you in the past, you know how they typically are, what their appearance is. And now observing them, if they're different in their appearance, if they're different in how they communicate with you, it's easier to notice. But what if you haven't had that much interaction, which is, that's not uncommon, especially right now, coming out of a pandemic, a time where we've been more virtual, then, we may not have seen the physical appearance other than someone's head, from a Zoom meeting that we may have had. So we may or may not be able to recognize any changes in their physical appearance. So what I like to do is start with statistical stuff. In other words, things that are easy for us, that come natural. If I ask you what your name is, that's natural. If I ask you what your date of birth is, it's a natural response because it's something you've known for your entire life. So I will start with those sorts of questions if I have some concerns about a client's diminished capacity and if I need to understand how diminished it is. If they have children, I want them to tell me their children's names. I want them to tell me their address. And then we go from there. So those questions become more and more complicated, obviously, depending on how diminished the client is. And if the client can't answer the primary questions, and I define primary by those statistical questions, the things that we've known for the entirety of our lives or a very good part of our lives, then that first tells me the level of that diminished capacity. So that's where I start with basic, very basic questions, just conversation. And it doesn't have to feel like an interview either, because if a client is already on guard, they're not going to want to go through what feels like an interview, right? What they're going to want to do is just talk to you. So it should be more conversational. So, Mrs. Doe, I know it's been a while since we've talked, so I've got to go through a few things. I want to update my file. Now tell me your children's full names. I got to make sure I have that correct here. And now what's your address again? And tell me your date of birth. If you find that there's some friction there, then it probably means or could mean that they don't know the answer, that they can't recall the answer. And diminished capacity does not have to be to that level. It doesn't mean that they don't know the statistical information. But what it does mean is that some of this information may not be top of mind anymore, right? And if that information that is primary to their lives, that has been second nature for the majority of their lives, is now not top of mind, then there may then be a difficulty with that client understanding the level of what they're doing in their estate planning. Or if they're signing a contract, they may not be able to appreciate that contract if they can't even remember the basics, of their life.
Perfect. So that actually leads me to my next question, because I was going to ask you, with clients who have that possibility of a diminished capacity and they haven't received any sort of formal diagnosis from a physician, how are you making sure that they're understanding what they're asking you to do and the legal implications of that?
Yeah, that's a good question as well. So going back to Rule 1.14, the rule specifically says that you look at the state of mind of your client and how that varies in terms of appreciating the consequences of a decision, the fairness of their decision, the consistency of your client in making that decision. And that's the piece that I like to focus on. If a client is talking to me about a decision that they're making in their estate plan, and let's say, for example, they have 5 children who all of whom they've provided for in their prior estate plan. And now they've come to me and they want to change that estate plan and they only want to leave their estate to one child, essentially disinheriting the other 4. Then that in my mind is inconsistent with what your prior decisions were, correct? So I now want to know why. So tell me what's led to you making these decisions. And again, being conversational with the client is way more helpful than just asking questions. If you ask an open-ended question, things that don't lead to yes or no or I don't know, then you tend to get more answers. You'll tend to allow the client to get more comfortable with what they're talking about, and they may or may not know the consequences of what they're saying either. So in other words, if I say, so I noticed that, you now want to provide for child number 1. Has something happened? And so what happened? Not just asking the first piece of that question, has something happened with the other 4 children, but tell me what's happened. Why don't you want to provide for your other children? And that allows more conversation. Or you can even be more general and say, why are you changing from your old plan? What's changed? And then you may get, half of the conversation may or may not be relevant to your discussion with the client, but chances are you'll get an answer. You'll now get more of a response from the client in terms of what's going on in their lives, right? They're not going to volunteer that most of the time. So when you ask that question, you may get answers like, well, daughter number 1 is taking care of me. I've been sick. She's really been good to me. My other 4, they're too busy with their lives. They don't want to provide for me anymore. And it could be a logical answer, but it could also present some warning signs that daughter number 1, child number 1 could be unduly influencing your client to make these decisions. Because these conversations may have literally come from child number 1, right? Child number 1 may be the one in the home with the client saying, well, I'm the only one who cares about you. Your other kids don't care. That's why they're not here. And she may or he may be feeding that misinformation to the client, leading her to make this decision. So I found that these open-ended questions tend to point to the true answers. And the true answer won't come from the client. It'll come from reading between the lines in the conversation with the client.
Okay, so you bring up a really good point that I wanted to ask you. So I imagine that in a lot of these consultations, meetings with these elderly clients, you have an adult child that often drove them or helped make the appointment. How do you make sure that you're hearing the wishes coming from the client and what they really want, and it's not being fed to them by that child?
Yeah, that's tricky. It's tricky, right? And it really depends on how long the child has been interacting with mom or dad. And it's not always a parent, it can be an aunt, uncle, it could be a best friend, but it really depends on the level of interaction they've had before they get to you, for you to be able to identify that. Sometimes it's very hard to see that. Sometimes it just may be that there's a more dominant child that's spending more time with mom or dad, that actually has the time to be able to sacrifice to take care of them. It may be that the other, in my prior example, the other four children, they may have small children, they may have full-time jobs, they may love that person very much, but just not have the bandwidth to be able to provide the care that they need. So it may be other reasons. The way that I start by trying to identify that is separation. Having this difficult conversation only in the room with the client. And I'm sure we'll talk later about how to identify who your client is. Once you understand that client is mom, in my example, then you have to have this conversation with mom outside of the presence of whomever has brought her to the appointment, whomever may have even set up the appointment, so that you can then have a private conversation with her and understand, really her underlying basis on making these decisions. So what I do first is, I'll start my meeting. If daughter brought her in, then well, so tell me why you're here, and then we'll have that conversation. And then I will say, well, daughter, thank you for bringing her, but now I got to have a conversation with mom on my own. So if you don't mind, can you wait in the lobby or maybe leave and come back in about an hour, and let mom and I chat so I can explain some things to her. And child number one's reaction might also tell you, some things too, right? Because if child number one is offended and or uncomfortable doing that, then that's a warning sign that child number one wants to make sure that his or her wishes are the ones that are being heard, not the parents. And so that's another thing. A lot of what we're going to notice here is action, less words, because nobody's going to outright say that they're there in your office for the specific purpose of disinheriting their siblings, right? Nobody's going to admit that out loud. Your client's not going to admit that they are being unduly influenced and forced to make these decisions from the child that's sitting next to them, right? And sometimes they don't want to admit that if the child is in the lobby. So we have to emphasize to them that whatever you say to me is confidential. You are my client. I want to do what you want me to do. I want to understand what you would like. And so separation is key in making sure that your client has the freedom to speak to you, and making sure that your client understands that they are in a safe place. Now, and kind of going back to the last question as well, when you do that, you also want to be very frank on the implications of what they're asking you to do. So if a client is asking you to make an unnatural decision in their estate plan, and when I say unnatural, I mean, just as in my example, a mom wants to leave her entire estate to one child versus the five that she has, that's an unnatural response to estate planning. And if a client is asking me to do that, I want to make sure that she understands or he understands the implications of that. So when I say be frank, I mean, this is not the time to be eloquent in our conversation, right? This is not the time to show and prove how eloquent and how wonderful of a lawyer we are. We are going to be a conversationalist in this moment. And we're going to say, listen, so is it your plan then? Do you understand that if I do this, those other four children won't get anything? That also means that their grandchildren won't get anything that you've accumulated. None of your estate would go to your grandchildren, your children. I have to say it like that because sometimes when I do, the client will say, well, no, that's not really what I want. What I really want is for child number one to be able to stay in my home if she wants to. And then at her death, I want all my children to split the proceeds of the house. So then those things come out later. And I learned that really it's not your desire to leave your estate to child number one, but you do want to give child number one a life estate, the opportunity to live in your home during their life. But if the house is ever sold, you now want the proceeds to be split among all of your children. Well, that makes a little more sense, right? But we can't get there without being frank, without saying, if I put this in this document, your other children and grandchildren will not receive anything that you've accumulated because this is what the document says. Do you understand that? Is that what you want? And then now I have more clarity, and they have more clarity that they understand the consequences of what they're asking me to do.
Okay, so I want to circle back to something that you mentioned earlier because you talked about determining who your client is. And I think that that brings up a really good point because, like we talked about, usually it's a child or a friend or a neighbor that's might be doing most of the talking. They're the ones setting up the appointment, the one you're interacting with the most. But who is your client in this situation?
So that is the first question that you have to ask yourself, even before the family comes into your office. Okay. Sometimes most attorneys don't have the opportunity to speak to these potential clients before they're in their door. So a lot of times, in a traditional sense of a law firm, if somebody makes an appointment with us, they're not calling me and I'm not scheduling them, right? They're talking to an intake specialist, they're talking to a receptionist, they're talking to your legal assistant, but they're not talking to you. And so what that means then is that there's a high possibility that one of those children are scheduling the appointment. So let's say all of that happens, and when you come into the room, there's 6 people in the room, which is not unlikely, you know, in this situation. So you come in the room, you're in the conference room, and you've got mom here, and then you've got her 5 children that are all sitting around the table, right? And the first question I say is, tell me why you've sought an attorney, why you need to speak to an attorney. What is it that is keeping you up at night? How can I help you? And usually there's a dominant person in the room that's going to speak, right? When that person speaks and they identify the issue, that's what you're listening for so that you can identify the client. So, well, dad just died a few months ago, and mom and dad had an estate plan that basically left everything to each other. Mom wants to make a change in the estate plan. Okay. At that point, I can then identify that my client is mom. Okay. It may be very different. It could be, as an alternative, mom is sitting in the room and never speaks. And there's a dominant child that says, well, mom she's been sick lately. And about a month or two ago, she had a stroke. She's doing okay. But we're all now concerned that, we need to be able to take care of her. So she needs to name one of us as POA, and then that now tells me that there is a potential conflict here, because if someone, number one, is saying that they're here for a power of attorney over someone who has had a medical emergency that could have likely impaired them, caused them some mental and or physical impairment, then a power of attorney may not be an option at this point. But before I can identify what the conflict is, I want to understand what mom's condition is. So I want to try to address her and see if she can communicate with me. And just because she's had a stroke doesn't automatically mean that she has diminished capacity, right? You could be physically disabled and not mentally disabled. That's totally possible. I've had many clients like that. So I need to have a conversation with mom, and I will ask mom, so tell me what you need. Tell me, what could you use some help with? And if mom is unable to communicate with me, then at that point, I can identify that mom is not my client, because mom does not have the capacity to retain an attorney. My client is the person who would like to be identified as the agent for mom. And if there is no power of attorney at this point, I as well can now identify that the estate plan that you came in here to talk to me about is non-existent. And we've got to now consider whether or not the least restrictive way to help mom is to go through a court proceeding. and to have someone appointed by a court as her agent, as what we call in Tennessee a conservator, as her conservator. But you can't identify any of that until you've allowed the family to tell you why they're there. Now, once you identify that, I'm gonna go through two scenarios just as I did earlier. Going back to scenario number one, if mom was able to speak to me and say, well, yeah, I've started to have some health issues. My daughter, Susan, has been helping me. I want her to be my power of attorney. I want to make sure that if I have another medical emergency, that she doesn't have to go through a bunch of red tape. I want her to handle my money. She's been helping me pay my bills. If she can communicate that well to me, where she understands the nature of why we're in this room, why you've come to my office, then that's my client. Mom is my client. If she can't speak to me, which is my scenario number two, if she's not able to communicate why we're there, clear enough for us to have a healthy conversation, a dialogue, then I have to identify which of the children are saying to me, I'm the one that, we all agree that Susan should be the one to take care of mom. Because then Susan might be my client in the future as the agent of mom. And those responsibilities are very different. They're very different. And if you don't identify who the client is at the onset of the conversation, then you could run the risk that once you accept the case and once you continue to work for whichever client you've chosen, that the family might have had the appearance that you were the family lawyer, that you actually represented me as mom's agents. If in fact I did not, and I accepted the representation over mom. And so if you don't identify that, then now you have a problem under Rule 0.17 of the Model Rules of Professional Conduct. And if in fact you have conflicted yourself out, then it may be that you can't represent either. So it's very important to identify who your client is at the onset of the conversation with the family.
Okay, so leading on to your interaction, once you've determined your client and you move on to working with them, whoever that is, have you ever had situations where, in speaking with the client, they seem to have capacity to understand their decisions, the impact of their decisions, but what they're asking conflicts with what you think would be in their best interest, and you don't think it's a wise decision? How do you handle that situation?
That's a great question. And that does happen a lot, so that's why it's important to know who your client is, because when you represent your client, you are representing them as their advocate. If mom is my client, I'm her advocate. Although I would disagree with some clients' positions that when they hire a lawyer, that means I'm hiring you to do what I say, right? I've had to correct that before and say, no, when you hire an attorney, you are hiring them to accomplish the goal that you've come to them for in the best manner possible. And yes, in that representation, they are your advocate. But it doesn't always mean they're going to just do what you say. If what you say is not ethical, if it is not moral, then perhaps we have an attorney-client problem, right? But as the client's advocate, sometimes we do have to advocate for things that our client wants, even if we don't think that's their best option, even if we've given them all the options. The key, though, is making sure that they understand all of their options. It is our responsibility to explain to the client all of the options that they have under their scenario, based on their life, based on their issues, what options they have. And if you give them three options and they choose to option number one, and my preference is number three, it's not my job to convince them to go my way. It is my job, though, to explain to them the consequences of every decision, of every option. Now, if a client wants to make a decision that is not in their best interest, so long as they have the capacity to do that, to understand the implications of that, there's no problem with that. I don't like it. As attorneys, do we want our clients to do exactly what we say all the time? Absolutely. Does it happen? Never. But A rational adult with mental capacity has the right to make bad decisions. And that, I think, is one of the issues that's come up so often lately, especially since you've seen, I'm sure, all of the conservatorships that have been in the news these last several years, all of the issues that we've had across the country and in our state. Um, it all stems from this concept that a person might make a bad decision. So I want to be their agent to help them from making that decision. Well, the only way under the law that you would operate in that manner, if you are a conservator, is if this person lacks the ability to do it themselves, if they lack the mental capacity to understand the nature of their actions, right? The consequences of their actions. But if a person does understand the consequences of their actions, they are permitted under law to do that, to do whatever it is that they want to do, so long as it is not against the law. If a client asks me to do something or is telling me that they're going to do something that is against the law, it is my ethical responsibility as the attorney to advise them against that, and in some cases withdraw from their case. So it really just depends on what the decision is. Not necessarily that the decision is just against what I want them to do, but that if the decision is if it crosses ethical boundaries, if it's a decision that is unlawful, then I have to advise them not to make that decision. And if they do, then I have to do all of the things that I need to do to no longer represent them. So it's a very sticky situation because clients want to do what they want to do. And sometimes they come to us just to give them the support, just to say out loud, well, you can do that. And that's not always what we do, right? Usually our response is more like, no, I don't think you should do that. I think that's a terrible idea. I think that you're going to cause yourself more harm than help because of A, B, and C. And so when that happens, when a client is wanting to make a decision that's not in their best interest, I think that all we can do as their attorney, so long as we know that they have the mental capacity to understand what they're doing, is tell them why we think it's not a good idea. And if that's the decision that they would like to make, then I think they have the right to do that.
Are there ever situations when working with elderly clients where the attorney might put themselves in an ethically compromising position? Or another way to word that, maybe examples where an attorney might be compromising their ethical standard without realizing.
I think so. I think it can happen, especially when you're doing multi-generational estate planning. So when you're doing estate planning for mom and dad, and then you're also doing estate planning for their children, there are potential situations that could come up where perhaps the children's understanding of something is different than the parents' understanding. That could put you in a pickle. It could put you in a situation where it may not be on its face a conflict of interest per se, but it can put you in an ethical dilemma if, in fact, you believe that one estate plan can hurt the desires of the other estate plan. I see that a lot when there are blended families, specifically and I can give you an example. If mom and dad want to leave some land, let's say they have 100 acres of land that stayed in their family, for years. And the plan is that mom and dad want this land to pass to their children, but they don't want it to pass to their children's spouses, right? They want to keep it in their particular bloodline. That happens a lot. Mom may say, well, this land came from my great great grandfather. I don't want, my daughter's husband to have this land later. But then if you're also having discussions with daughter and her husband, then that conversation could come up where daughter says, well, I would like my portion of the land to pass to my husband, and to his parents or whomever. That's an ethical dilemma because that that's not what mom and dad want. Is that on its face a conflict of interest? I think it really depends on how the conversation comes out. sometimes when you have these multi-generational estate planning clients, you start this conversation together as a family. And if you start that conversation, I do believe that it is the responsibility of the attorney to then seek a waiver of conflict among the family. Because if you seek a waiver of conflict and they've all signed it, then you now have the ability to say to daughter and husband, well, it's my understanding that your parents want this to stay in the family and they don't want it to go that way. So let's talk about how we can make sure that everybody's estate plan gels well, right? That's the way that you avoid that potential conflict of interest scenario that could come up.
So, what guides or resources might an attorney use when they're working with clients and they have an ethical issue come up that they're just not sure what the right answer is? What can they consult for help?
I have a couple of answers for you there. I know I've talked a number of times about the model rules of professional conduct, but more specifically, I would look at your state bar rules for professional conduct because it may very well address the scenario that you're dealing with. Sometimes I've had situations that were unusual, though, that, there's not a lot of discussion in any states or in the ABA model rules of professional conduct that would address that scenario. What I would do in that situation, in Tennessee, an attorney can seek an informal opinion from the Board of Professional Conduct. If you are concerned that there is a potential situation that can cause you some ethical problems and you just want to know what to do, then you can seek an informal decision from our board, and that decision can help guide you. And they are very helpful. And I've had to do that a number of times over the years where situations have risen and I wasn't quite sure what the right response was, what the best response. Should I withdraw from this case? Am I obligated to talk to my client about this? Should I report my client on something? What do I do in this situation? And the Board of Professional Conduct has been very helpful in explaining to me what our rules in Tennessee require me to do. And that is honestly, that should have been my number one answer. Once you read the rules, if your rules of professional conduct don't speak to what you need, what your situation is, seeking an informal opinion from your board is really and honestly the best way for you to get an answer. Now, NALA, the National Association of Elder Law Attorneys, is very helpful. They have aspirational standards, which I have utilized previously under certain situations. And those standards are very detailed. And they, in fact, there are comments in these standards that will speak to different scenarios that are very common among elder law attorneys, which of course is still under that same umbrella of estate planning. Elder law is a little, unicorn, I believe, in the estate planning world, but the aspirational standards speak to that and speak to scenarios that are regular scenarios that those of us who are working with seniors in the community and making sure that their estate plan is what they want, that we should be aware of and that, we may have to deal with at some point. So I do encourage attorneys to look at those aspirational standards because it explains to them really how your practice should be operating and what your model should look like and if you're not doing something, what you should be doing. One last really, really helpful handbook that I would recommend any attorney that works in an area where you're dealing with the possibility of working with diminished capacity or clients with diminished capacity on a regular basis is there's a handbook for lawyers that actually was published by the American Bar Association in conjunction with the Commission on Law and Aging and the American Psychological Association, and it's called the Assessment of Older Adults with Diminished Capacities. It used to be a PDF some years ago. Now you can actually order the handbook. Years ago, I utilized that PDF, and I'll tell you the specific example. I had a client who wanted me to draft a power of attorney for her grandmother who was in a nursing home. And I went, of course, to visit with grandmother to make sure she understood the the consequences of naming an agent under a financial power of attorney. And I was very concerned because at that time, I think that was probably the first time I'd visited a client for this purpose in a nursing home. So I was very concerned that it may be that grandma does not have the ability to understand what's going on here. So I printed out that handbook and I went to the nursing home. And it actually has the most wonderful checklist and the most wonderful questions that you would ask a person that's in that nursing home. Now, it went through a lot of the questions that you would ask. It went through things that you would focus on when you're speaking with someone who has diminished capacity, and it had some checklists. And I'll make sure to send you a link to that publication because, like I said, now you can actually order the handbook, but it really does give you interview questions for your clients when you have concerns with diminished capacity. And it is published by the American Bar Association, and it is a wonderful, wonderful publication. And I do want to give a special shout out to the Commission on Law and Aging. I have served as a commissioner for a number of years now. I work with a number of very, very educational individuals who have dedicated their lives to teaching us how to do this. So I would encourage all attorneys who work in this area to look on the website for the Commission on Law and Aging and look at all of the resources that are there to help you when you are working with seniors.
Perfect. Thank you so much for your time today, Chastity. You have provided us with so much good information and resources. We're so happy you were able to join us today. Thank you so much.
You're very welcome. Thank you for having me.